I did not look back at it. All rise.
Please be seated. Good morning, everyone. Welcome to the March 7th, 2023 Topeka docket for the Kansas Court of Appeals. We have two cases on the docket this morning. My name is Angela Coble. I'm one of the newer judges on the court, having been sworn in last spring. Today, I'm joined by two giants of the bench, and that's not just because I'm a short person. To my right is Judge Stephen Hill. Judge Hill served as a district judge for 22 years. Before joining our court in 2003. So that makes Judge Hill the longest law-trained judge in our state. And to my left is Judge Gordon Atchison. Judge Atchison joined our court in 2003 after a 29-year career as a litigator. So I'm honored to sit today with both of these distinguished jurists. And the three of us then make up the panel hearing your cases today. So I guess a bit of housekeeping, everyone can hear okay, and we're good with the YouTube, everything's going. Okay. We've all read your briefs and we've all reviewed the records on appeal. So we're familiar with the facts of the cases and the issues presented. So just keep that in mind as you're presenting your arguments today. That said, just remember that we're also live streaming and there may be spectators both in person or virtually that are not as familiar with the facts of your case. So I'm going to ask appellant's counsel to maybe take just a brief minute at the beginning to just give us a short summary of how we got here today. And then I'll start your argument timing after that introduction. As the presiding judge, I'll also act as the timekeeper. So if you see me looking at my phone, it's not because I'm distracted. Each side will be given 15 minutes of argument. And if appellant's counsel could let us know at the beginning if you would like to reserve time for rebuttal. After you present your arguments, the case is deemed submitted for decision, and we'll endeavor to get a written opinion out to you as soon as possible. So with that, we'll go ahead and get started, and I will call the first case. Our first case this morning is case number 125352, and that's Blue Valley Telecommunications, Inc. Versus the State Corporation Commission for the state of Kansas. If I could have appearances from counsel, please, for the appellant.
Yes, good morning, may it please the court. My name is Colleen Jamison of Jamison Law LLC in Tecumseh, Kansas. With me today is Mark Doty of the law firm of Gleason and Doty Chartered from Ottawa, Kansas. I would like to reserve 3 minutes for rebuttal if I can.
Okay.
And for a short factual synopsis of the case. So Mr. Doty and I
Oh, I'm sorry. Let me get appearances from the
I'm so
appellee
sorry.
first. No, you're fine.
Thank you. Good morning, Your Honors. Brian Fedotin, General Counsel on behalf of the Kansas Corporation Commission.
Perfect. Thank you. Okay, you go ahead and begin.
Sure. So for a short factual synopsis, as the court's requested, Mr. Doty and I represent the majority of small rural independent telephone companies across the state of Kansas. These are companies that have long served the communities in which they provide service. They serve in areas of the state that are extremely sparsely populated. They serve in areas of the state that large companies like Southwestern Bell and the former Sprint Local would not serve. Prior to the 96 Tele-Comm Act, their rates, their cost of providing service to their end user customers was derived from sources that were mainly rates. During the 96 Act, the Kansas legislature decided to replace one specific type of rate with which at that time it was an implicit subsidy with an explicit subsidy from the Kansas Universal Service Fund. It was initially a dollar for dollar replacement, and later it went to a cost-based fund. In 2016, the Kansas legislature decided that it would without reason really to cap that fund at $30 million.
Excuse me if you would, counsel,
yes.
in your recitation. I am curious to understand the viewpoint of you and your clients on the purpose of that cap. Did the legislature ever explain why they wanted to cap it or
No, sir.
anything? And it hasn't reached that.
Oh, yes, it has. It's well over it.
It has been over it now for
Yes.
some time.
Yes, the cap itself was reached in like 2 years ago, I think.
Right. So it took some time to get up to that point.
Correct. In 2016, when the cap was initially instituted by the legislature, the amount of high cost support received by the rural companies was about $26 million. So it was about $4 million under the cap. Right now, if companies were to receive the amount that the KCC has said that we should receive absent the cap, it would be at over $34 million.
So, and again, the purpose of the cap, in your view, was what?
I don't know, punitive, maybe, I don't know. There was nothing stated by the legislature as to why, what was there, why they instituted it.
But in your view and in the view of your clients,
Yes,
it's confiscatory?
yes.
All right, tell me why.
Because rate of return regulation is a contract between the companies that I represent and the state of Kansas. State of Kansas, and that's for any publicly regulated utility. Even gas companies like Kansas Gas Service and Black Hills, electric companies like Evergy, right? So they're a natural monopoly in the areas that they serve. It would be economically unfeasible for another company to come in and overbuild them. So the regulatory contract that the state has it that they say, okay, well, we're going to tell you what you can charge your customers for providing them service. We're going to require you to limit your service to a specific area. You can't serve outside of that area. And we're going to tell you what you can charge them. But in return, we are going to guarantee that you have an opportunity. I'm not saying that what you're guaranteed to earn, but you have a guaranteed opportunity to earn what we say that you need to cover the cost of you doing business, plus to provide you a small margin for an additional revenue for profit for your company in hopes of attracting private investors. That's a longstanding rate of return regulation principles. It's been described several times in courts at the U.S. in cases at the U.S. Supreme Court. Our contention is that the state has breached that regulatory compact by not providing us with a source to replace what it has taken from us in the form of KUSF support.
In your explanation of this, I didn't hear the words "to ensure competition" as well. Or is competition ignored in this algebra of returns?
In these specific companies' areas, there is effectively not competition from other telecommunications carriers. In order, there has been in the past, but it is a steep burden for an entrant into our company's areas to climb, because the areas that they serve are so sparsely populated. We're talking maybe 1 or 2 people per square mile, that there's no business case there for a competitor to come in. So if competitors were allowed to come into the areas that we serve, without being required, like we have a requirement to be a carrier of last resort to provide service within our service territory to any requesting customer. If they don't have that same obligation, they're just going to come in and cherry pick from the more populated towns and leave us to serve the more rural customers, that it doesn't make economic sense for a competitor to serve.
I was interested in reading in the record Meredith's testimony, and both before the commission and then I think before the district court as well. Loss is not really losing money. It's not making as much money as you could. Is that right? Am I understanding that correctly?
At the time that Mr. Meredith presented the testimony to the Kansas Corporation Commission, right? And we have to remember that he was a very high level policy type witness, because his testimony was presented to the KCC within the timeframes of a CAPA petition for reconsideration of a commission order. We were not afforded an opportunity to actually have, because of those time limits, a full-blown evidentiary hearing where we could have presented a witness on each individual company's loss. And at that time, as the testimony, I believe noted, the lowest amount of money lost by a company was $163 annually, and the highest amount was a little over $161,000 annually. Today, that has ballooned to over $544,000 annually for one company, one of the largest drawers from the KUSF. To one of the smallest losses is just over $26,000 a year for a company that has less than 400 access lines. So you know, the KCC has said several things. First of all, well, you need to, it's a legislative fix, right? They've also said, well, there's ways that you can that you can recover this money that you're losing. Well, one of the ways is, I suppose, potentially a rate increase under KSA 66 2007B, which allows a rural company to raise in any 1 year rates $1.50 per month without going through a full 8-month rate case proceeding. That's not a guarantee. If enough customers protest, you know, the KCC would actually have to do a full investigation. And that for my client that has less than 400 access lines, that would only raise an additional $7,200 in revenue for them, not the $26,000 that the cap has taken from them. So we would have to have 4 consecutive years of $1.50 per year rate increases to come anywhere close to receipt to making up the $26,000 that we're losing currently. And that doesn't take into account the fact that I know that there are companies waiting in the wings to come to the KCC to what is essentially shuffle the deck chairs on the Titanic.
These figures that you have given us, are they in the record?
They are not, because those records were just in a KCC employee's testimony filed at the KCC in a docket to determine new statewide affordable rates that would be in effect March 1. This was testimony that was filed in December. And see, that's kind of part of the problem, right? Because it's ever growing, and so we have not had a chance to show just how much it is now and how much bigger it's going to be getting in the future.
Can we then take those into account in our opinion, these figures that you tell us today? Or since they're not in the record, can we even consider them?
That's unfortunately, that's the nature of the ever-changing situation in which we find ourselves here, right? So
basically your argument is your situation is worsening every year.
That's correct.
And what's the threshold then? So how much profit do your clients need to lose to make it confiscatory? Like what is the threshold for confiscatory? I mean, just as Judge Hill said, in our record, we don't even know, the amount of the reduction in profit. So at what point does it become confiscatory?
I guess my argument would be that it's that the confiscatory part is the fact that the legislature took away from us a source of revenue, which we have to remember. That source of revenue, its ancestor was a rate that the legislature said, you can't charge that anymore, but we're going to replace it with the KUSF. So now they've taken that away, but they've not given us anything else to replace it. That's what we're saying is confiscatory. Not the amount, but the fact that they took away a rate that they had originally promised us and said, you can't charge that anymore, but they didn't give us anything else to replace it. So we have no ability to earn what the Kansas Corporation Commission has said that we should be earning. They've determined that the client that I have they should be getting $544,000 per year more than from the KUSF than what they are getting. The KCC determined that was reasonable for my client. The cap prevents them from earning that, and it's only going to increase because the entire industry in Kansas is under earning.
You want us to adopt a rule that says it's a unconstitutional taking anytime the rate of return is less than what the KCC says is the reasonable rate?
No, I'm asking you to adopt a rule that says that it's confiscatory to take away a rate without giving us another source from which to earn the rate that you've taken away.
Regardless of the impact of the loss of that rate.
I suppose that there could be a rate taken away that was so de minimis that it doesn't make sense to have it applied in that situation. I don't think $544,000 a year in climbing is de minimis.
We don't have anything to measure it against. How much is that company getting already under the,
We would love an opportunity to be able to show anybody that, but we've not been given that opportunity.
and how are we supposed to find that it's confiscatory?
Again, my contention is that the confiscatory part is that they took away a rate that they promised us and didn't provide us with a sufficient source of revenue to make up
Are you
that.
arguing then that any cap is confiscatory? In other words, the existence of the cap itself is confiscatory. Is that what I'm hearing you say, or I don't want to put words in your
Unless-
mouth?
No, that's, I appreciate the opportunity for clarification. No, my argument is not that the cap is confiscatory. My argument is that the action of the cap combined with an absence of another available source of revenue from which to make up the losses we are experiencing from the cap is unconstitutional.
What would be another source in your view? I mean, what would be a reasonable source? Is the legislature handing you more money? I mean,
No,
Sorry.
we don't have it. That's the point, but we've not been given an opportunity to demonstrate that.
well, no, but I'm just asking in terms of this industry, what would that be? I mean, it would be another amount of money from the government, wouldn't it? Or, I mean,
Keep in mind that the KUSF is not money from the government.
no,
It is money distributed, it is
from other
other,
users.
right, correct.
It comes through the government. I'm fishing around for what's the alternative source and how is it different from KUSF?
There is none. There isn't any.
Okay. I mean, what would it be? I mean, if you were to go to the legislature and say, you got to fix this, or we say it's confiscatory and they have to fix this, what do?
They take away the cap, yes. I mean, that's the problem is that the KCC has at various times said you could do this and you could do this and you could do this. Well, I know that we can't, but we've not had any kind of proceedings afforded to us to be able to show that. And I would point out that the KCC, I think the KCC has a duty to help us find the money that we're losing from the KUSF, right? The Supreme Court of this state has said that it's the KCC's duty to balance the interests of the regulated, or the ratepayers with the regulated utility.
Well, I guess what I'm fishing around for, because this is not my area of expertise, is what is a source or an example of something that would, if the cap remains in place, it's taking away a revenue source. What is an alternative source of that revenue? Is it tax dollars or is it some other kind of levy on other providers that filters through the system, which is simply effectively getting rid of the cap? I mean, I'm fishing around for what it is you think is a fair replacement.
I don't believe that. So this is for intrastate, the company's intrastate revenue requirement. There are three sources for a company right now as the system exists today for a company to earn its intrastate revenue requirement. That's the intrastate portion of funds that it receives from the federal government, end user rates, and the KUSF. The KUSF, remember, is a replacement for a former rate that we were allowed to charge, intrastate access rates.
But that was a policy decision of the legislature.
Right, which also decided to make it a dollar for dollar replacement because they recognized that they could not take away a source of revenue without providing us with an equally available source of revenue and an opportunity to access that. And what they've taken away is thus our opportunity to access any other source of revenue that will allow us to achieve what the state says we should be achieving.
Okay, Council,
Thank
thank
you.
you. Hear from the applicant.
May it please the court. Good morning. My name is Brian Fedotin. I'm general counsel for the commission. The RLEX only witness in this case Douglas Meredith, testified that the legislature can make whatever changes it wants to the KUSF, including abolishing it completely. That testimony is uncontroverted. So surely the legislature can pass a cap and prorate the amount of annual subsidies the RLECs receive.
Council, that's all given.
Sure.
We understand that. The concern that I have in looking at this docket and then looking at the history before the commission and Meredith's testimony is we've got people out in the country that depend on their phones.
Sure.
And if these phone systems go belly up, what are they going to do?
Sure. Well, let me point out, first of all, that this is just landline. This is not mobile service and other forms of communication. And there's been no showing in that any of the RLECs are losing money, or they've not even pled that they're unable to meet any of their obligations. So we're a long, long way from that ever happening.
Test, I mean, that they have to be in a negative revenue position as opposed to earning substantially less than what is recognized as a reasonable rate of return?
Well, this court has already said that in Twin Valley, which Twin Valley is, as you guys know, is one of the plaintiffs in this case, but Twin Valley has already, this court's rejected the argument that in order that results in a rate of return less than the authorized reasonable rate is not a takings. I mean, just a.
Yes, I wrote that. So I know what I intended.
Sure.
And it's not that it has to be a loss. It just has to be a confiscatory amount that reduces the profit. It doesn't have to throw them into a negative position, which it seems to me what you're saying.
Sure. Well, there's been no showing that you know, I want to clarify the record. It was, you guys were told earlier this morning that we didn't have a full evidentiary hearing. We did. And Douglas Meredith testified. A telecom staffer who's in the room, Sandy Reams, testified and was not cross-examined. Meredith's testimony was that he never examined individual company records. And so we have no information, and the record is devoid of anything on how much, other than we know the one figure that the smallest cut was $163 and the largest one was about $162,000. But we have no additional information on that. We don't know what any of the RLECs rates of return are. None of that is in the docket, and the RLECs had a full opportunity to put all of that in the record. So there's no showing before. There's nothing that would suggest anything is confiscatory. I mean, I think from what I heard this morning, we've gone back and forth in what is considered confiscatory. Is the sheer fact that we have a cap confiscatory? And at one point, it seemed like the answer was yes. And then it was, well, as long as it's not de minimis. So the argument is shifting, but there's nothing that suggests it's confiscatory. And I don't think there's any suggestion that a loss in profit.
It seems to me that the phone companies are making a systemic argument that the cap necessarily at some point will become confiscatory, and we're fast approaching that. I mean, is that a legitimate argument as opposed to, I mean, Twin Valley was a much narrower, this particular company has to show a substantial loss in revenue, and they didn't.
I don't think it's a legitimate argument because it's not supported by evidence. It's overly speculative. Such an argument wouldn't be considered ripe because we're not there yet. I mean,
well, are we going to be there in 2 years when this stuff from last December comes up to us?
I don't know. I mean, the cap did slow the growth down. I mean, the cap was initially in, I believe, 2013, and it took basically 8-9 years for them to hit the cap. I would think that if the cap remains in place, that there may be some more fiscal responsibility, and if they know that the cap is in place and here to stay, you may see some more efforts at better managerial tactics and some less spending, they may put their books more in order. There may be some consolidation of the industry, which the Blue Stem case talked about that may be the future. Again, KUSF is for the end user, for the customer. It's not a guaranteed revenue source.
It seems to me, though, that you can't have it both ways. If you end up denying service to the public, that's not a benefit. Just to have some sort of artificial cap that says we're going to cap your profits.
Again, there's
Doing business for the public.
other than speculation that the RLECs are putting forward today, and they haven't briefed or didn't argue at the hearing, there's no speculation that there's no evidence that any of the RLECs are in danger of not being able to provide service to their customers.
I ask your opposing counsel this question. I'm going to ask,
Sure.
What's the purpose of this cap? What was the legislative purpose of creating this cap? Changing the rate of return that they negotiated that was working and replacing it with this cap. What was the purpose?
Well, Meredith testified that he thinks that it may have been due to the decreased use of landlines, and so we're funding an outdated technology that is disappearing. But I would guess too that the legislature was frustrated by the growing expenditures, and if the subsidy is unlimited, there's nothing that requires anybody to tighten their belts or to run a company efficiently. If I give you an unlimited subsidy, you don't have any real incentive to be efficient. And I think that's what
they stopped the rate of return and substituted it with KUSF and then put a cap on it.
But that gets to one of your other questions, that part of the 1996 Act was to promote competition, and they got rid of the Access and KUSF. That's totally different from what they did in 2013.
Now you're talking about consolidating. Maybe we could save money that way, and that gets rid of competition, doesn't it?
Well,
the big ones eat up the little ones. Is that now competition?
that's in Blue Stem. This court talked about, the 1996 Act does not guarantee all local telephone service providers a sufficient return on investment. Quite the contrary, it is intended to introduce competition into the market. Competition necessarily brings the risk that some telephone service providers will be unable to compete. The Act only promises universal service, and that is a goal that requires sufficient funding of customers, not providers. I hope that answers your question. If not, I'll take another stab at it. But and we heard about the regulatory compact and how other, all these other utilities and their rate of return. The gas industry, the Evergy, the electric industry that you heard about this morning, none of them receive subsidies. The rural telecom industry is unique. They're the only ones that get the subsidies. And that might have been something that the legislature looked into as well, that these subsidies continue to grow and grow. You heard you heard from about, when the cap was in place, that it was, I forget what the exact number was, $26 million. Now you're hearing that it's $34 million. That's a tremendous growth in a short period of time. But the big issue, again, is this is an issue for the legislature. This is not for the courts. The RLECs are perfectly free to go to the legislature and say the cap is we need different sources of revenue. We need a higher cap. Abolish the cap.
I have one final question, Council. Are we bound to follow anything done by the district court in this case?
You're not bound to follow the district court, but I think the district court did a very thorough job, and I think their analysis, the district court's analysis, is really good. But in terms of your question, I mean, this is not de novo review. If you read the RLEC's brief and their conclusion, they're arguing that this is unconstitutional and should be stricken. And that's a very high burden. It's not a de novo review. They bear a very, very high burden of proof to show this is an unconstitutional statute, and that the well-established case law is that statutes are presumed to be valid. And there's been no showing at the commission, at the district court, or here that it's unconstitutional. And this whole need for alternative sources of revenue, the RLX keep arguing that, but they did not provide any authority to support that at the commission. They didn't do it at the district court. They didn't do it in the briefs, and they don't do it this morning, because there is nothing in the law that requires alternate sources of revenue to go with any cuts to KUSF. And again, if they think they need those, they should go to the legislature. The case law in this is very strong. I mean, in Twin Valley, in Blue Stem, in Moundridge, this court expressed concerns over the size of the KUSF. It noted that the RLX must be tasked with providing service with minimal subsidies from the government. So, there's, I'm not sure how much more time I have. I can.
3 minutes.
Okay, good. I didn't want to go over, but again, the RLX only witness, Mr. Meredith, admitted that earning a state prescribed rate of return on investment is simply an opportunity. It's not a guarantee. A rate of return is not a fixed number. It's a maximum. And Meredith, in his own testimony, said that most rate of return carriers don't actually meet their rate of return each year. So the fact that somebody doesn't meet their rate of return is not confiscatory. And Twin Valley even talks about a subsidy is of a different nature than, if somebody was going in and actually capping profits or things like that. Excuse me. And I just wanted to note in follow up to Judge Hill's question that, yes, you're right, that some of the new figures that were given this morning, not only is the commission not seen, they're not in the record, they can't be considered, and it would be unfair to do so. And I'm still at a loss based on what I've heard this morning on whether the idea that an ROR, or I'm sorry, rate of return less than what's authorized is confiscatory, or whether it's a de minimis standard. So I think we've got to stay with the existing case law, and that's Twin Valley, and the fact that there's no evidence that the RLX are losing money, that it's simply that they may see a smaller profit margin. I don't think that there's any grounds to find that's confiscatory. And certainly if it's not confiscatory, it's not a takings under the law. And briefly, just want to note that there was some briefing about a statutory conflict that would invalidate the cap. I think the plain language of the cap is very clear that all the factors used for the KUSF are subject to the cap. The district court did an excellent job analyzing the statutory conflict argument. The RLX never discussed his analysis, never contradicted his analysis.
1 minute, Council.
Thank you. In Twin Valley, again, mentions that the legislature made an unmistakable policy choice that the KCC and the court must respect. That's what's true here. As Mr. Meredith admitted, managing the KUSF is the province of the legislature. How to manage the KUSF is a policy decision best left to the legislature. If changes are needed, go to the legislature, not the courts. The $30 million cap and the resulting pro rata reductions in support are constitutional. The commission respectfully requests this commission to find both the cap is constitutional and to deny the RLX petition for judicial review. Unless you have any other questions, thank you very much for your time.
I have to admit that I find it somewhat troubling that the KCC's allegations to here is that the companies that I represent are fiscally irresponsible. When given the fact that it is the KCC that determines what companies should be receiving in KUSF support. They are fully vested with the power to, if they think that we are being fiscally irresponsible, to call us in for a full audit, to take a look at all of our interstate revenue requirement, cost, investment expenses. They haven't done that. Additionally, the KCC every year holds a proceeding in which it takes a look at the amount of both state and federal USF support received by each company. They do a thorough analysis of that support receipts, matching it up against expenditures that we provide them evidence that we've made, and they could, if they so chose, determine, well, that's, looks like something's fishy there. We'll call them in for an audit. They've not done that. The one time that they've done that, in 2013 in Twin Valley, they determined that not only was the company not over earning, they were actually under earning by $15,000. And it should have been, had there not been a small anomaly in the law that was later rescinded by the legislature, close to $800,000 that the company was actually under earning.
Yeah, I don't think fiscal irresponsibility is an issue here in front of us. I mean, that's
appreciate
not
that
what's going
recognition.
on.
Thank
I mean,
you.
I can't speak for my colleagues, but I don't think that that's a factor in either the constitutional or the statutory issues in front.
And again, I would just like to reiterate that it is the fact that we have no other opportunity to earn what the state has said, what the KCC as the arm of the state has said that it is reasonable for our companies to earn.
The relief that you're asking for us is to just simply brand this statute as unconstitutional and set it down.
Yes, sir.
That's it.
Yes, sir.
Not asking for remand to the commission, not asking for reinstatement of the former, anything of that, if that
this
was
court-
even within our power.
Pardon me for interrupting. If this court were to order remand to the KCC, we would welcome that, so that we can have a full-blown opportunity, not the context of a high-level policy witness who had no time to, due to the constraints of the Administrative Procedure Act mechanism in which we found ourselves in the context of Mr. Meredith's testimony, an opportunity to have a full hearing where we were able to present into the record what each company is losing and how there is no other available source of revenue from which we can earn our state allowed opportunity to earn what the state says we should be earning. Thank you. Appreciate your time.
Thank you. Okay, again, thank you, counsel. We'll consider the case deemed submitted, and we'll get an opinion out as soon as possible.
Thank you.
Thank you. Well, we'll go ahead and call our next case. Next case on today's docket is case number 125181. And that is the Junction City Police Department versus $454,280 in US currency, more or less, a 2013 Chevy Silverado, 2015 Lance Camper, suspected trace amounts of marijuana and drug paraphernalia. As defendants, Robert Henderson, appellant, and Oregon Community Credit Union appellee. Could I have appearances, please, for the Junction City Police Department?
Antonio Cruz on behalf of the Junction City Police Department.
And for the Mr. Henderson.
Yes, Robert Henderson appears through counsel Mike Francis, and also with me is Mr. John Andreas, who appears pro hac vice, and he will argue the case if it pleases the court.
And just a little bit of housekeeping here before we start. We had a motion for an addition to the record that was just filed actually yesterday. just want to clarify if is there an objection to that motion?
That there is, Jack.
Okay,
Of the timeliness.
right. Okay, well, we'll go ahead and let the response period play out and take that motion under advisement.
All right, thank you.
Okay. Do you wish to reserve any time for rebuttal?
I believe you want 5 minutes.
5 minutes for rebuttal, Your Honor.
Okay, that's granted. Okay, and you go ahead and begin.
Good morning, may it please the court. My name is Jonathan Andrus. It's my privilege to be here today on behalf of the appellant, Robert Henderson. This case involves a traffic stop that resulted in what the appellant claims was an unreasonable search and seizure under the Fourth Amendment. The issue here, or the point of contention, is that the district court erred by refusing to rule or consider the motion to suppress that was filed in the civil forfeiture case. Instead, the district court accepted and adopted the ruling on the similar motion to suppress that was filed in a criminal case in which Mr. Henderson was the defendant. And we submit here today that the decision not to rule on the motion to suppress was an error for several reasons. Reason number one, June 22nd, 2018, a very important date, because of that day, the law in the state of Kansas changed in terms of the analysis for assessing whether a traffic stop exceeds the permissible scope or time permitted under the Fourth Amendment. On that day, the Kansas Supreme Court issued 3 opinions, primarily Jimenez, Schooler, and Lowry. Another case that was issued that same day, ironically, was Carpenter versus United States, and I'll get to that in a minute, but I want to focus first on what I'll call the Jimenez cases.
Before you get there, I wanted to clarify what I understand your argument to be. You're not making an argument that as a categorical procedural matter, collateral estoppel cannot apply. Your argument is that it shouldn't be applied in this particular case because there were significant changes in the law. Is that correct?
The appellant's position is that collateral estoppel applies generally, but should not apply in this case, because in this case, we have a unmixed question of law. There's no factual issue. So it's strictly a question of law. Collateral estoppel should not apply. The principles of collateral estoppel that the Kansas Supreme Court discussed and applied in the Capers case, we think is directly relevant. The court in that case pointed out that collateral estoppel is a flexible doctrine, should not be rigidly applied. So therefore, that provides some room for analysis here. It's not just a rubber stamp application of a legal doctrine. Secondly, the Kansas Supreme Court said in that case that collateral estoppel does not apply on an unmixed or pure question of law. And there was emphasis, as we cited in that opinion, the court emphasized the word not, but the point being, whereas in this case, you have a unmixed or pure question of law relative to whether there was an unreasonable search and seizure, collateral estoppel should not apply.
How is that an unmixed question of law? I mean, typically it's a mixed question of fact and law. Is this case different somehow?
What's the difference?
Well, no, is it not a mixed question?
Well, I think collateral estoppel might apply where you have a mixed question, which is the facts are different and you're trying to apply the law to a different set of facts. Here, the facts are undisputed and identical.
Well, just a second. You're arguing, are you not, that this stop was too long?
Yes, it was
That's your
unreasonable
contention, and that's what you were going to
under the
argue.
Jimenez analysis, yes.
And that's a question of fact, isn't it?
It's a question of law applied to undisputed facts. Because the facts don't change. We're not introducing new facts. The point being that the reason the district court should have decided the motion to suppress is illustrated by State v. Brown, the case that we cite. And I'll just remind the court that in State v. Brown, a case where the motion to suppress was denied by the district court, the Court of Appeals affirmed in 2017. Jimenez comes along, gets decided in June of 2018, excuse me. The defendant in State v. Brown goes to the Kansas Supreme Court. The Kansas Supreme Court vacates the Court of Appeals decision, sends it back to the Court of Appeals for analysis under Jimenez. And I want to point out some things. We're not citing Brown for the decision. I mean, that's not the issue. The point is that Jimenez was a sea change in the analysis of the legal analysis of unreasonable searches and seizures under the Fourth Amendment. And in what I'll call State v. Brown 2, the court came to the same conclusion, but admitted, look, Jimenez forced us to change our analysis here. And so it was a question of law. The facts didn't change between Brown 1 and Brown 2. Same here. Facts didn't change from the criminal case, or the facts that were presented in the criminal case and the facts that were presented in the civil forfeiture case. Identical. So therefore, under Brown and the Kansas Supreme Court's view that Jimenez is so important that it should be, decisions should be reassessed under what we now say is the proper analysis. That's the reason collateral estoppel should not apply here. And that's also the reason why the facts haven't changed. Nothing's changed. I mean, this is a replay of Brown, or State v. Brown in the appellant would submit. So to answer the question, this is not a mixed question of law and fact. This is exactly the kind of situation that this Kansas Supreme Court in Capers said is one where collateral estoppel should not apply. And the final cite from Capers that I wanted to point out on collateral estoppel is the court there said that the case that presents a purely legal issue constitutes in and of itself a sufficient basis upon which to preclude application of collateral estoppel. So I would just emphasize, before I move on to my next point, but emphasize that the facts didn't change between the criminal Henderson and the civil forfeiture Henderson. They're the same. And Brown is an illustration that Jimenez, Schooler, and Lowry are so important in the Supreme Court's opinion, the cases that don't consider Jimenez and the proper analysis under that.
Does it make any difference that those cases were all pending in the appellate process when Jimenez was decided?
Does it make any difference that which cases were pending?
Those cases, Brown, for example, was pending in the appellate process when Jimenez was decided. And we have a longstanding doctrine in Kansas that says, you know, if the Supreme Court changes then the rule, then everything that's pending in the Court of Appeals process, it applies to those cases as well.
I recognize and acknowledge that principle. I would submit, Your Honor, that because of the discussion in Capers about collateral estoppel, that pendency issue doesn't control here. Instead, what controls is the issue or the circumstance that we have a pure question of law that was not decided by the district court in the civil forfeiture case that we submit should have been decided because A, it presented a pure question of law, collateral estoppel does not apply, and B, State v. Brown illustrates that the Jimenez change in analysis, if you will, or one that at least the Court of Appeals recognized created a change in their analysis, should be applied here. It's that important.
Also, they have a remand order from the Supreme Court that says reconsider your opinion based upon Jimenez, and a good Court of Appeals panel will follow the Supreme Court's order, would they not?
Yes, sir.
Maybe a little confused, but I thought I saw something floating around in the materials to us that in the suppression hearing in the criminal case, that piece of it, that the district court did in fact consider Jimenez, and it had been decided at that point. Am I mistaken in that?
Here's what you may be recalling floating around, as you say. The motion to suppress in the criminal case was filed on June 22nd, 2018, the very day that Jimenez was decided. On the I want to say the 24th of June, a few days later, there was a supplemental filing on the motion to suppress that I think mentioned Schooler, or one of the cases that had, sort of just 3 days old kind of thing.
Yeah.
So that may be something that is I'm responding to what you're
Well, I
referring to.
guess, but I mean, I had the impression that the district court, in considering the motion to suppress in the criminal case, had available to it Jimenez, and may even have alluded to that, and based its decision in part on a finding that the stop had not been unduly prolonged. Am I mistaken in that?
Jimenez was raised. I mean, it had just come out, so it was cited, as I said, and I think the supplemental motion to suppress. But I'll say this, what I think I'm responding to what you're saying, Your Honor. Just as in Brown 1 versus Brown 2, the analysis in Brown 1 followed sort of what I'll call the pre-Jimenez analysis. Brown 2, the court says, look, yeah, we just read Jimenez and we were compelled to change our analysis. Moving to this case, the motion to suppress order in the criminal case, which was decided under an analysis that was pre-Jimenez. I mean, it's not an issue in this case, but they got it wrong. But that's not an issue here, as I said. Now, when you move forward to the civil forfeiture suppression motion, the post-Jimenez or the Jimenez analysis should be applied. And I submit that that's the case because of what the Supreme Court did in State v. Brown, which says we're going to vacate your prior opinion because we think, your analysis doesn't consider what we think is important. So that's another reason why the appellant submits that the district court should have decided the motion to suppress. We're not arguing what the result would have been. We don't know. We're saying, look, we deserve our day in court. We deserve to have our motion decided, and collateral estoppel doesn't apply. It's a pure question of law. And we want district court, we request that you decide it under Jimenez, Schooler, and Lowry. And we know that's important for the reasons that I just mentioned.
Just about 45 seconds, Council. About 45 seconds.
Okay, I wanted to mention Carpenter. Carpenter was a case where 7 days of historical cell phone records were designed or deemed an unreasonable search and needed a warrant. Here, the license plate data that came in was from 3 different states, as I recall, Massachusetts, Missouri, and I think there might have been somewhere on the West Coast. Carpenter applies here too. It should have been applied and considered to rule on the motion to suppress, and for reasons that we discuss, is another basis on which the stop here was violative of the Fourth Amendment.
I've got a question about that, if I could, please. Is it your argument then that cell phone site information is equivalent to
May I respond to that?
Yes, please.
I'd like to
I'm
respond to that
asking you a
because
question.
that is a,
If the PJ probably won't penalize you for this.
yes,
You get to stand there as long as we got questions, even if we're out of time. So,
I'm ready to answer.
well, and
Uh,
I've got one to probably follow up on that, but please answer Judge Hill's
I'm
question.
going to answer that question by starting with a bedrock principle that was announced in Carpenter. There, the Supreme Court said that there exists a reasonable expectation of privacy in the whole of a person's physical movements. And as such, Carpenter found that the government access to the cell phone location information contravenes that expectation. Before we move on, it's important to unpackage that. The expectation of privacy, what is it linked to? The person's physical movements.
What is your expectation of privacy in a license tag that you're required by law to put on the front of your car or the back of your car, or in some states, front and back of the car? What's your expectation of privacy in that?
On a Tuesday afternoon at 4 o'clock in Topeka, if my license plate gets a picture taken of it, no problem. But equating it with the cell phone records, if that little mosaic tile gets pulled out and gets put up on the wall with a license plate reading of last Thursday, a month ago, and gets put up and it shows where I've been, it's no different than the cell phone records, because the cell phone records, they were piecing it together on a 7-day history where the person had been based on their cell phone pinging records. So it's again, it's the bedrock principle that it's the reasonable expectation of privacy for physical movements, not location. Big difference. Tuesday afternoon, photograph of my license.
So your argument is
It's a
in the
location.
aggregate, it's the aggregation of
It's the mosaic principle that we
I-
discussed in the reply brief that is gaining more traction, or at least has been recognized by legal scholars as a principle that was acknowledged at least by the Supreme Court in Carpenter. So I hope I've answered the question that it's
Yeah, but I've still got my question.
the question. Now I'm ready for the next question.
This is a little more granular. As I understand it, at least some of the license plate information was collected by the Boone County Sheriff's Department, which would be Columbia.
Yes,
And I presume, and I assume this is in the record someplace, that the sheriff's office maintains some kind of a reader that picks up the tags on cars going on I-7. Is that how that's collected?
Boone County has 2 locations within within Boone County that pick it up. They have a licensing agreement with the State Highway Patrol. This is all detailed in the record.
Okay, well,
But the agreement says you can't share that. I mean, unless you're in a relationship, dotted line relationship with us, you can't just throw it all over the place.
okay.
Well,
but
here's what that
it's
was
the gov-
happening here.
It's the government, a government agency is collecting that, and what it's collecting is the license tags of the vehicles traveling eastbound and I presume westbound on I-70 in Boone
Well, it was
County.
an unauthorized transfer is our position between the Boone.
I'm not asking about that part of it. I'm asking about the mechanics of what was, is that, am I correct in my understanding of the mechanics of what was being collected?
The mechanics were that law enforcement intrastate were exchanging it
That's
between
not what
Missouri
I'm
and.
asking. I'm asking,
Maybe I'm not understanding the question.
well, I'm simply asking, is the Boone County Sheriff's Office had this information because it has 1 or 2 readers posted that read the license tags of cars going eastbound and westbound on I-70. That's how it gets the information, right?
Yes, Your Honor.
Okay. And there's this, after that, what they do with it is your gripe is that they shared it when they shouldn't have.
They turn it into a 7-day record of cell phones. They turn it into the
I understand
mosaic.
that. Okay, I'm just trying to understand the mechanics of where
Yes.
the information or how it originated. And I
Yes.
think, I mean, okay,
It's, as I understand, and again, I'm a little bit out of my depth, but there's different databases that exist with these license plate readings
okay.
that get shared or amalgamated or, synthesized to the point that you now have a picture that would,
Right.
as
No, I mean, I
Carpenter said, it was
understand what you're-
information that would not otherwise be knowable.
Yeah, if there's a whole bunch of them out there and you collect all of it, you can see where someone's license tag has been. And that's the mosaic.
Yes.
Okay.
I would only say that if my license plate is taken in front of McDonald's on Topeka Boulevard, that doesn't tell you that I've been to Utah or Arizona.
I get what you're saying.
So that's the reason we submit that Carpenter applies here to the analysis of unreasonable searches and seizures under the 4th Amendment, and that the cell phone data is directly relevant and analogous to the license plate reader. And we cite the case Leaders of a Glorious Struggle versus Baltimore Police Department. They had an airplane that they use to sort of survey the whole city. I won't get into all the details, but the point is, since Carpenter, there have, that's what the Fourth Circuit opinion that said, hey, Carpenter has application, it's not just limited to cell phone records. Any other questions I might ask or answer? Thank you, Your Honor.
Mr. Cruz will be similarly flexible with your time.
No problem. May it please the court. Antonio Cruz on behalf of the Junction City Police Department. And to answer kind of some questions, Judge Rozier in the 2017 criminal case did in fact make rulings based on the defendant's supplemental motion to suppress, which included citations to Jimenez and Rodriguez. So those issues were in fact addressed by the court, and they're meant.
Is there a written ruling? Or is that a bench ruling? Where he just
That was a bench ruling. There is a journal entry that just is very generic, if you will. It says, the parties present their evidence that the motion is denied. But a reading of the transcript of that hearing, Judge Rozier does in fact cite, and I quoted it in my brief, that's in volume 1, pages 1151 through 1152, where he acknowledges the argument about Jimenez and the travel plan questions. And Judge Rozier says, as applying to Officer Blake, so he's continually moving forward in the enforcement action, and the questions he asked, we're not extending that the traffic stop. So the issues that they're now claiming are new law or new rules of law. Those are already addressed by the district court in the criminal case.
okay.
So again,
Well, reading, in all fairness, in reading the judge's decision, he did not use the name Jimenez or
Correct.
Rodriguez or anything like that.
correct,
But the analysis is in there that certainly seems to be that he was cognizant of that rule.
correct, because prior to Rodriguez and to Jimenez and to Lowry and Schooler, there would have been no reason for a district court judge to question the lengthening of a traffic stop due to travel plan questions, because up until those decisions came down from the Kansas Supreme Court, all of our appellate courts had found that travel plan questions were part of a regular traffic stop.
And
So-
to connect it up with this particular case, the case that we're here for, the
Yes.
civil forfeiture case, the trial judge did read the transcripts
Yes.
of the criminal case.
Yes, and I know that part of their brief also mentioned that the fact that that Judge Rozier in the criminal case did not have access to the preliminary hearing transcript, which quite honestly, that's not even relevant, because a preliminary hearing, you don't get into the weeds, if you will, on the issues for a suppression motion. That's why you have suppression motion. So the facts that are drawn out during the suppression motion, that's what that the court rules on. So even if there are other facts that popped up during the prelim, those don't matter, because again, the court made its ruling based on the evidence that was presented by the parties during the suppression motion.
Before we get off of
Sure.
that topic, and I apologize for sort of getting granular about the record. When, at the time that Rozier made the bench ruling, Jimenez by name had already been called to his attention in a supplemental submission. Is that correct?
Yes, sir.
Okay. So while he didn't cite it by name, it had been called to his attention and the parties had addressed it.
Yes.
Do you recall if it comes up by name in the argument to him, or does he just rule without any argument? I can go look. At the record. I mean,
I don't recall if any of the parties addressed Jimenez by name. However, again, because the fact that he was talking about the travel planning questions and how they would relate and possibly extend that the traffic
I
stop.
mean, I can go look at that. I mean, that's not really
Yeah.
a
So,
fair question. Let me try to ask one that I think is sort of fair. Obviously, Mr. Henderson has also said that Carpenter is a sea change in the law.
Mhm.
And obviously it was not discussed because it hadn't been decided. What's your response to that? Why does that not defeat collateral assault?
Because I don't think, I don't think that they cited Carpenter in their motion to suppress. And if they did, they never brought it up to the district court's attention in the civil case saying, hey, we have a new rule of law. And I think that the fact that they didn't bring it up and give the district court notice that there was this other rule of law out there that hadn't been addressed, I think that's inviting error. Because again, all they would have had to say is, Judge, yes, there is a ruling on the motions to suppress. However, we have new law. This court needs to address it. I couldn't find anything in any of the transcripts or on the record where Mr. Henderson or that his attorneys ever put the district court on notice that there was a new.
Let's put aside the procedural default for a moment. On the substance of it, is Carpenter a sea change in the law that would affect the outcome?
No, because if someone were to read Carpenter very closely, Carpenter just didn't deal with the fact that you could track somebody through their cell phone. The technology that was used in Carpenter did much more than that. It actually tracked what text messages were being sent to and from that cell phone, and also tracked the phone calls. So it wasn't just the mere GPS location of the person having that cell phone. There was a lot of other type information that was being conveyed or collected. And that's why the U.S. Supreme Court.
The substances of the text messages were available, and also some of the information concerning the oral conversations, correct?
Yes, yes. And that's why the U.S. Supreme Court said that their decision in Carpenter is very narrow to that specific type of technology. And I don't recall if it was in Carpenter or one of the other cases I cited in my brief, but our U.S. Supreme Court has held that certain types of technologies, such as surveillance cameras, those aren't something that falls under the guise of these prohibitions about needing to have a search warrant. And this is no different. And as Judge Hill noted, that license plate readers just record license plates, which there has been no case law that I'm aware of that says that a person has an expectation of privacy in their license plate. This is, and the various appellate courts that have addressed that issue have said this is no different than if there was a police officer off the side of the road and he either taking pictures or had a video camera marking every single vehicle. There's nothing, again, there's no expectation of privacy because those license plates are mandated for a very particular reason. And that is so that the general public and law enforcement will know the identification, if you will, of a vehicle if there's an accident or the DUI or for traffic violations, so that the dispatchers know who or potentially who a police officer has in fact stopped. So
the mosaic theory, though, is that if there are enough of these readers out there, you collect all the data from them, you get a picture of a person's movements or the movements of their car over a period of time that is comparable to the GPS information in Carpenter. I mean, what's your response to that?
Carpenter, no, because the LPRs, they're in various places, but you cannot track a car 100% of the time as you would with the GPS.
I saw them do it on TV.
Well,
that doesn't really work that way.
No,
All right.
the same way that that you watch CSI and in 20 minutes they've got DNA, they've got fingerprints, and every technician happens to be an expert in soil samples and tire tracks and paint chips. No, the LPRs, if they're working properly, and there are ways to defeat LPRs. Some of them are that intentional, meaning people can't put types of plastic covers over them so that the cameras don't read them. Other times there's weather conditions, snow, mud, dirt, that can also affect it. And sometimes it's just the angle that the cameras are at that can't get the picture of that plate. But those LPRs are in random places. So, like for example, I think tag T has them. So if there's one in, say, Topeka, and there's one, say, in Denver, all you really know is that the car was in Topeka on this date at this time, and then some other date and time that it was in Denver. But it doesn't tell you if it went to Wichita or if it went here, went there. It's just on this day it's here, on that day it's there, and that's pretty much it. Not, that they stopped at the Pamigo exit and got the fried pies, and then went to Manhattan and did shopping there, and then went to Salina and did shopping there, and went to Lowe's and went to here. None of that information happens to be available when using the LPRs. You get very small bits of information. In Carpenter, they were tracking them basically the same way that the CIA does it. I mean, they had them where they knew who they were talking to, who they were texting, and where they were at. This is completely different technology than TLPRs.
What about Mr. Henderson's argument that the information that was collected by the Boone County Sheriff's Department on I-70 somehow got transmitted to the Highway Patrol and then in turn to the officers here, and that was a violation of some sharing agreement? I mean, first of all, is that premise correct? And if so, does that make a difference?
I believe just so everybody's on the same page, there were two different motions to suppress, one in front of Judge Segura and one in front of Judge Rozier. The motion to suppress in front of Judge Segura addressed that very issue. And we had Sergeant Prim from the Missouri Highway Patrol testify at that hearing. And he advised that it was his practice and his understanding that that information could be shared with law enforcement, that the agreement or the conditions that they not disclose that was meant to be applied to the general public, not for law enforcement. And that was his understanding. And when Judge Segura ruled on that very issue, she found that there was no violation, that was information that was available between two law enforcement agencies, and found that was not a basis to suppress. I'd ask the court to uphold the district court. Thank you very much.
In brief rebuttal, I'd like to just make the following comments. Jimenez did not reflect a change in the law as much as it reflected a change in the analysis under the law. Jimenez emphasized that the court in Kansas should no longer determine whether traffic stops are impermissibly extended by comparing the duration to that of a typical or ordinary stop. Before, I think courts were saying, well, this seems pretty reasonable, it seems pretty typical, the dog alerted, et cetera. Instead, the court said that you need to see whether there was any non-consensual inquiries unrelated to the mission of the stop that prolonged the stop, even by a de minimis amount, without reasonable suspicion or consent. And I would point out, remind the court that the key analysis on this point that we present is in our reply brief at pages 4 and 5. And there we analyze what the district court in the criminal case, and how their analysis attract Brown 1, I submit, in denying the motion to suppress. And we also point out what the district court should have considered was not the length of the video. I mean, if you read the judge's ruling, he says, yeah, I guess the video is moving along. We cite that at pages 1 and 2 of the reply brief. We cite or we quote the opinion. So I won't go through that at the moment, but Pages 1 and 2 of the reply brief set the stage. Pages 4 and 5 unpackage it. But I'll just summarize by saying that the analysis there, when you read it in light of Jimenez and Brown 1 and Brown 2, the district court should have decided the motion to suppress because there was faced with an unmixed question of law that should have been decided under the controlling analysis at the time, as explained in Jimenez. And the court instead adopted what we submit as pre-Jimenez analysis or an emphasis or an analysis that the Supreme Court has recognized was applied in Brown 1 and said, no, we're not going to accept that. We need you guys to take another crack at it. And that's what happened in Brown 2. And we think that the district court in this case should be invited to give us their version of Brown 2 by deciding the motion to suppress under the legal analysis. So for those reasons,
I've got a question, if you will, please. Your opposing counsel argued that you did not raise Carpenter before the district court in this civil case. Is that correct?
we did not raise what?
Carpenter?
Carpenter?
Yes, and the ruling in Carpenter did. And if you did not, is that something that should affect our decision? Since you did not raise it in the court below, can you raise it now for the first time on appeal?
Here's my response, Your Honor. We preserve the objection to the search as being unreasonable under the Fourth Amendment. Carpenter simply provides another log on that fire.
But did you
But-
or did you not raise Carpenter specifically before the district court? That's my only question, I guess.
Look, I don't have a specific amount. I mean, the records is what it is. I thought we had
You've
mentioned
got a
it
good
somewhere
memory.
along the
You would've
lines.
re- you
But if it
would've-
was not in the record, I'm not going to argue with the record. It's a point that I'd like to,
Council brought it up and I
Sure.
wanted to verify it.
sure. That's about as much as I can respond to at the
All right,
moment.
thank you.
And I have no further comments unless there's any questions. We would ask that the decision of the district court be reversed.
Thank you, counsel. That concludes our docket for this morning. At this point, the court will stand in recess. Thank you.
Good morning.